Across the civilized world, laws are supposed to shield the innocent from harm, restrain the dangerous, and serve as the silent backbone that keeps society from collapsing into a very expensive demolition derby. But somewhere along the legal assembly line, a few statutes, loopholes, and court precedents slip through the cracks. Rules so baffling, so backward, and so unintentionally generous to criminals that you'd swear a prankster had hijacked the drafting committee. These are the laws that allow burglars to sue homeowners for injuries sustained during break-ins, the clauses that let thieves claim emotional damages, and the procedural tricks that erase confessions simply because someone forgot to check a bureaucratic box. In a system designed to deliver justice, these oddities operate like hidden trapdoors, ones that don't catch criminals but cushion their fall. Most citizens assume the law behaves like a stern parent, firm, predictable, occasionally disappointed. But as we dig into the legal archives, we find moments where the law behaves more like a confused uncle who accidentally rewards bad behavior because he didn't read the instructions on the box. Across decades and across continents, well-meaning regulations grew strange appendages. Ancient laws never died, and modern courtrooms handed out rulings that seemed allergic to logic. Each example is real, documented, and still lingering in the files of a system that occasionally prioritizes procedure over reality, technicalities over truth, and due process over common sense. Today, we're opening a confidential report on the statutes that don't just fail to stop crime. They drag a chair over, offer it a blanket, and ask if it needs anything else. Fasten your seatbelts. Logic is about to die a spectacular death. 1. In several U.S. states, burglars who injure themselves while breaking into a home have successfully sued the homeowner for unsafe conditions. Courts ruled that property owners owe a duty of care to anyone on their premises, even uninvited criminals navigating through shattered windows. These cases hinge on technicalities that prioritize liability formulas over common sense. When your break-in ends with a cash settlement, the justice system starts to feel like an unintentional rewards program. 2. England once upheld a case where a car thief sued the vehicle's owner because the anti-theft device deployed too aggressively and startled him. The court debated whether protecting one's property should be allowed to inconvenience the person stealing it. Lawyers argued procedural ethics, while the victim sat there wondering how reality had become optional. In the end, the thief got compensation, proving that irony is apparently admissible in court. 3. In California, a shoplifter used a loophole to sue a store after security tackled him, claiming excessive force, despite video evidence of him stuffing merchandise into his jacket. The law required that even suspected criminals must be restrained with careful proportionality, a phrase vague enough to start philosophical debates. His injuries were minor, but his legal payout was not. Crime didn't pay, but civil litigation did. 4. In some European countries, if police enter a home without perfect procedural compliance, even when catching someone in the act, the evidence can be thrown out entirely. Judges defend this as protecting citizens from abuse of power, but criminals treat it like a technical scavenger hunt. One missing signature can dismantle an entire prosecution. It's less justice served and more paperwork wins again. 5. In the United States, identity thieves have successfully invoked privacy protections to block victims from accessing information about how their identities were used. The law protects personal data so aggressively that even stolen personal data remains shielded. Victims end up locked out of the crimes committed against them, while the perpetrator hides behind confidentiality clauses. It's privacy theater at its most inconvenient. 6. In Canada, a burglar once sued a family after tripping over their kids' toys during a break-in, claiming the clutter was hazardous. The judge entertained the case because liability law technically applied to anyone on the property. The family watched the proceedings like hostages to absurdity. Criminals shouldn't get participation trophies, but here we are. 7. In certain U.S. jurisdictions, drug dealers can sue customers for failing to pay because contract law doesn't automatically void illegal transactions unless contested. Courts don't enforce the deal directly, but they sometimes allow restitution claims on bizarre technical grounds. This creates the surreal situation of criminals invoking contract rights they legally shouldn't have had in the first place. Apparently, crime comes with customer service. 8. In parts of Australia, trespassers injured while fleeing from police can sue the government if the area they ran through wasn't properly maintained. The logic? Public land must be safe for everyone, including those running from law enforcement. Officers must document terrain conditions as if chasing criminals through a botanical garden. It's hard to uphold justice when the shrubbery becomes evidence. 9. In the United Kingdom, a man who broke into a home with a knife sued the homeowner for assault after being hit with a cricket bat. Prosecutors argued the homeowner used disproportionate force, sparking nationwide outrage. Though the burglar lost eventually, the fact the case progressed at all highlighted the absurd fragility of legal interpretations. Sometimes the law protects criminals from physics. 10. In some U.S. states, police cannot use evidence found in a suspect's trash unless they follow strict collection protocols, even though the suspect literally threw the evidence away. Defense attorneys argue privacy lingers until the trash truck arrives, creating a bizarre limbo where discarded items are both abandoned and protected. Criminals exploit this gap with almost artistic precision. When even garbage enjoys legal nuance, something has gone profoundly off script. 11. In several U.S. states, car thieves have sued vehicle owners after injuring themselves while attempting to steal the car, arguing that the steering locks or anti-theft mechanisms were unreasonably dangerous. Courts, bound by liability frameworks, sometimes allow these cases to proceed long enough to generate settlement pressure. Victims end up explaining in court why their own property was not sufficiently gentle toward the person trying to take it. When the law treats theft like a customer experience issue, reality begins to wobble. 12. In Italy, a burglar who fell from a skylight while breaking into a school sued the government for failing to maintain the roof safely. His lawyer argued that even trespassers deserve protection from structural negligence, and the court agreed, awarding damages the school could hardly afford. Students returned to class under a hole created by a man who profited from it. Only in bureaucracy can falling through the ceiling lead to landing on a pile of money. 13. In France, a pickpocket filed a complaint against a tourist who restrained him too forcefully after catching him mid-theft. French law emphasizes proportional response, meaning citizens must defend themselves with near philosophical precision. The tourist spent weeks navigating red tape, while the pickpocket claimed emotional distress. When self-defense requires a legal dissertation, petty crime starts to feel like performance art. 14. Some U.S. states require homeowners to post clear warnings if they use guard dogs, even if the only visitors expected are burglars, who definitely weren't invited. Criminals injured by the dogs can argue they weren't given fair notice, invoking animal liability statutes meant for delivery workers. Meanwhile, the homeowner must defend the moral right of a dog to protect its own house. It's a strange world where burglars get more consideration than the pets defending the property. 15. In certain European countries, hackers caught infiltrating networks can suppress evidence if investigators fail to follow precise digital forensics protocols, even when the intrusions are fully documented. Judges insist strict adherence protects everyone's rights, but cybercriminals treat it like a high-stakes game of procedural Simon Says. One misstep by investigators can erase months of work. It's justice by technicality where the keyboard wins. 16. In a widely cited U.S. case, a man who tried to steal copper wiring from an electrical station was badly shocked and later sued the utility company for inadequate fencing. Because the area wasn't signed with enough warnings, the case gained traction despite the obvious criminal intent. The company spent more time explaining electricity than the thief spent in the hospital. When stealing live wires becomes a litigable hazard, the grid isn't the only thing short-circuiting. 17. In Germany, a burglar successfully sued a homeowner after being locked in a garage for 2 days with no food or water. Although he entered unlawfully, the court ruled the homeowner had a duty to ensure the intruder wasn't trapped in life-threatening conditions. The burglar walked away with compensation, while the homeowner walked away wondering what dimension of legality he'd stumbled into. Sometimes the crime scene becomes the complaint form. 18. In some U.S. states, if police forget to recite Miranda rights at the exact correct moment, a suspect's confession, no matter how detailed, can be thrown out. This protects civil liberties, but also turns the process into a linguistic tightrope walk for officers. Criminals study these loopholes like exam material, hoping the detective stumbles over a verb. Justice becomes grammar-dependent, which is never a reassuring sentence. 19. In the Netherlands, a bike thief who was injured by a faulty lock sued the manufacturer for unsafe design, claiming the broken mechanism caused him to fall mid-theft. Liability law requires companies to anticipate potential misuse of products, creating absurd scenarios in which they must protect people misusing them deliberately. The court didn't award full damages, but it entertained the claim long enough to confuse everyone. When stealing a bike becomes grounds for a consumer complaint, civilization feels fragile. 20. In New Zealand, a man who attempted to rob a bakery sued the owners after slipping on a freshly mopped floor, arguing they failed to display a warning sign. The court acknowledged that premises liability technically applies to all individuals on the property. The bakery faced legal bills, while the robber faced only minor injuries. Crime shouldn't come with workplace protections, but the law doesn't always agree. 21. In the United States, several courts have ruled that burglars can claim excessive force if homeowners defend themselves with anything beyond the minimum effort required to escape the threat. This means frightened families must make split-second decisions that lawyers later dissect like philosophical puzzles. Prosecutors have debated whether a lamp, a bat, or even a pan counts as reasonable, while burglars sit in court describing their fear of household objects. When criminals get to grade your self-defense technique, justice starts sounding like a bad talent show. 22. In Spain, a thief who fell while climbing a drain pipe to rob an apartment was able to collect disability payments because the fall technically counted as a workplace accident, his work being burglary. Legal definitions didn't distinguish between legal and illegal occupations when assessing injury claims, creating a bizarre parity between criminals and actual workers. The public was outraged, but the paperwork didn't care. When crime becomes a profession on official forms, something fundamental has slipped. 23. In the U.S., some states bar victims from suing criminals for damages if the criminal has already served their sentence, treating the matter as fully resolved by incarceration. This leaves victims responsible for medical bills, property loss, and long-term trauma that the justice system considers already addressed. Criminals, meanwhile, walk out with their debts wiped clean, while victims carry theirs indefinitely. It's accountability turned upside down, where finishing your sentence erases the consequences for everyone except the person harmed. 24. In Ireland, a burglar sued a pub owner after being shot with rock salt during an attempted nighttime break-in, arguing the defense was inhumane. The pub owner's improvised deterrent was judged too aggressive, despite the burglar entering with clear intent to steal. The lawsuit sparked national debate on whether breaking the law grants special protection. Only in legal paradoxes does criminal intent come packaged with moral immunity. 25. In certain U.S. states, if police surveillance cameras malfunction or fail to capture clear video, suspects can argue that the lack of footage violates their rights, even when other evidence is overwhelming. Defense attorneys frame it as a failure of state responsibility. turning broken electronics into a legal shield. Prosecutors are left explaining how reality still exists without video proof. In the age of cameras, not being recorded can be more useful than being innocent. 26. Some Scandinavian countries require police to compensate suspects for emotional distress if they are detained longer than legally allowed, even if the suspect is later convicted. The intention is humane oversight. The result is criminals receiving payouts for procedural delays in cases where their guilt is unquestioned. Victims rarely receive anything comparable. When scheduling errors become revenue streams, the justice system begins to resemble a customer service hotline. 27. In the U.S., a man sued the homeowner he was robbing after the homeowner used zip ties to restrain him until police arrived. Lawyers argued that improvised restraints were untrained methods, making the homeowner technically liable for any bruising. The case didn't succeed, but the fact it reached court exposed the legal system's fragile boundary between self-defense and liability. It's exhausting when even your zip ties need lawyers. 28. In Japan, a convicted stalker sued his victim for emotional harm after she moved houses to avoid him, claiming her relocation caused him distress and disrupted his routine. While the case was dismissed, it forced courts to address whether avoiding danger could be considered harmful to the person creating the danger. The absurdity became a cultural talking point. When victims must consider the feelings of their pursuers, logic has clearly resigned. 29. In the U.S., some state laws allow criminals to profit from selling their crime stories, unless victims actively challenge the earnings under Son of Sam statutes. This means the burden falls on victims to monitor book deals, film rights, and interviews, or risk watching offenders get paid for narrating their own wrongdoing. The legal loophole turns infamy into an asset class. When storytelling becomes more lucrative than rehabilitation, something is deeply off-key. 30. In the United Kingdom, a burglar successfully appealed his sentence after claiming that prison food violated his human rights due to dietary restrictions he never disclosed prior to arrest. The court granted accommodation and reduced his sentence, prompting public outrage. Victims watched as the man who ransacked their home received menu upgrades. Only in modern jurisprudence can lunch determine liberty. 31. In the United States, a bank robber once sued the bank he attempted to rob, claiming that the teller should have known he was not in the right state of mind and refused to hand over the cash. His attorney argued that the bank's compliance with the demand note enabled the crime and contributed to his emotional instability. The case made it far enough into the system to require an official dismissal. When criminals expect customer service level intervention during a robbery, the law starts sounding like satire. 32. In Sweden, a burglar who fell asleep while robbing a home later sued the homeowners for returning and startling him awake, claiming the shock caused a back injury. Swedish courts briefly entertained the complaint due to national standards on safety and occupant responsibility. The homeowners were forced to defend their right to enter their own house without warning intruders first. When waking up a thief becomes a potential liability, sleep is no longer the strangest part of the crime. 33. In some U.S. states, DUI suspects have argued, and occasionally succeeded, that their charges should be dropped if the breathalyzer machine wasn't calibrated within a precise time frame, even when their blood alcohol levels were obviously high. Courts often side with technical accuracy over practical evidence, turning the device into a fragile oracle whose mood determines justice. Defense attorneys treat calibration logs like sacred scrolls. When a machine's routine maintenance outweighs public safety, the system feels programmed for absurdity. 34. In Belgium, a man convicted of burglary sued the homeowner for using motion-activated sprinklers, claiming the unexpected burst of water caused him to slip and injure his shoulder. Liability law required the court to assess whether the sprinkler constituted a hazard to unanticipated visitors. The hearing sounded like a weather report gone wrong. When burglars start critiquing landscaping, legality becomes horticultural comedy. 35. In the U.S., some defendants have used a loophole, allowing them to cross-examine victims directly if they choose to represent themselves, forcing victims to face their assailants in court. Though technically a constitutional right, it has led to traumatic confrontations where criminals interrogate the people they harmed. Judges can intervene, but the loophole remains a procedural relic. When justice permits psychological ambushes, the courtroom becomes a theater of discomfort. 36. In Germany, a thief successfully sued police for property damage after officers broke his lockpick set during arrest. The court acknowledged that, although the tools were used illegally, they were still his possessions and deserved reasonable care. The ruling sparked national confusion about protecting criminal toolkits. When burglary equipment gets more sympathy than victims' belongings, judicial priorities start looking avant-garde. 37. In parts of the U.S., suspects can request compensation for wrongful arrest due to clerical errors, even if they were committing a separate, unrelated crime at the time of capture. The law separates the mistaken arrest warrant from the actual wrongdoing caught incidentally. This technical split allows criminals to collect payouts while still facing charges. When paperwork errors turn into side income, the incentives start to blur. 38. In South Africa, a car thief sued the police after being bitten by a canine unit during a chase, arguing the dog used excessive force. Courts considered whether the dog's response followed protocol, producing hearings where trained officers defended the instincts of a German Shepherd. The thief limped away with medical coverage. When dogs must justify their enthusiasm, jurisprudence has wandered off-leash. 39. In the U.S., some states require that criminals injured while evading police, by jumping fences, tripping over curbs, or crashing stolen vehicles, receive full medical treatment funded by taxpayers, regardless of circumstances. The policy intends humane treatment, but often leaves victims footing their own bills. The contrast is hard to ignore. When fleeing the law guarantees better benefits than obeying it, the system starts looking upside down. 40. In the United Kingdom, a man who attempted to rob a charity shop sued the organization after cutting his hand on a glass donation container. The charity had to hire legal representation despite overwhelming evidence of the attempted theft. Courts debated whether the container posed an unreasonable hazard. When stealing from charity comes with hazard pay, moral gravity has clearly reversed itself. 41. In the United States, a home intruder once sued a homeowner after being shot in the leg during a break-in, arguing that the homeowner should have fired a warning shot first. His lawyer framed the injury as a failure of graduated response, as if burglary came with an etiquette guide. The case dragged on long enough to cost the homeowner thousands in legal fees, despite the intruder's clear intent to commit a crime. When defending your own house must be done with theatrical choreography, justice stops feeling like justice. 42. In Denmark, a man caught stealing bicycles sued the police for emotional trauma after officers chased him on foot for several blocks. He claimed the pursuit was psychologically aggressive and worsened his anxiety, prompting an official inquiry into acceptable chase procedures. The police were forced to justify why running after a fleeing criminal was necessary. When criminals demand gentler pursuit options, law enforcement begins to resemble a customer support department. 43. In the U.S., a burglar sued a city after injuring himself in a storm drain he used as an escape route, alleging the infrastructure was unsafe for emergency use. The court had to examine whether public utilities owed a safety duty to someone using them as part of a crime. City officials found themselves explaining that storm drains were not designed as criminal transportation tunnels. When criminals critique public works, the absurdity becomes municipal. 44. In South Korea, a man convicted of serial fraud sued one of his victims for defamation because she warned others about him online. He argued that her post damaged his reputation more than his actual crimes did, forcing courts to parse the delicate boundary between truth and social harm. The victim faced fines for speaking accurately. When honesty becomes a liability and deception becomes a protected asset, the moral compass is spinning. 45. In Australia, a burglar bitten by a homeowner's pet parrot sued for medical costs, arguing the bird was dangerously unrestrained. The court reviewed the claim because animal liability statutes technically apply to all intruders, regardless of intent. The homeowner had to defend the right of their bird to react naturally to a stranger rifling through drawers. When even parrots require legal disclaimers, the boundary between comedy and legislation dissolves completely. So far, we've watched the legal system twist itself into shapes so elaborate they'd make a contortionist wince, producing outcomes so backward that even the criminals involved seem surprised by their good fortune. So far, we've seen scientists weaponize dolphins, governments panic over clouds, and people who genuinely believed the Earth was allergic to satellites. Somewhere out there, common sense is screaming into a pillow. Across these 45 entries, a disturbing rhythm emerges, a pattern stitched together from procedural rigidity, outdated statutes, and an unwavering belief that the law must protect everyone, including the people actively dismantling it. We've seen burglars sue for unsafe floors, thieves demand emotional damages, and hackers shield themselves behind privacy laws designed to protect the innocent. At times, the legal code behaves less like a guardian of order and more like an overly polite host terrified of upsetting its most chaotic guests. Even something as simple as a guard dog or a broken fence can spiral into litigation worthy of a courtroom farce. The strangest part isn't that these cases exist, it's that they persist. They're remnants of systems designed with noble intentions, fairness, due process, humane treatment, mutated into loopholes wide enough for entire crime syndicates to somersault through. Judges follow the letter of the law, even when the spirit has clearly left the building. Victims sit in courtrooms wondering how their suffering became an administrative footnote, while offenders navigate legal protections with the finesse of seasoned bureaucrats. These absurdities don't reveal a broken system. They reveal a confused one, unsure whether justice should be a sword, a shield, or a customer loyalty program. And in the vast archive of human misjudgments, few things are stranger than laws so careful, so cautious, and so catastrophically polite that they end up protecting the very people they were meant to restrain. Maybe stupidity isn't the opposite of intelligence. It's what happens when intelligence goes unsupervised. And nowhere is that more painfully visible than in the labyrinth of laws meant to protect society, but occasionally end up shielding the very people tearing at its seams. These cases don't just expose unusual legal quirks. They reveal a deeper contradiction inside modern justice. A system built to be humane, rational, and fair can accidentally contort itself into something timid, hesitant, and oddly deferential to those determined to exploit it. The law is supposed to be the spine of civilization, yet sometimes it bends so far backward that it forgets which direction it was meant to stand. What makes these stories more unsettling than funny is how universal the pattern is. Across countries and decades, we see the same instinct. Safeguard rights so thoroughly that even bad actors inherit protections they were never meant to enjoy. Prosecutors navigate a minefield of technicalities, victims navigate a maze of red tape, and criminals navigate the whole system with the confidence of frequent flyers who know exactly which procedural shortcuts lead to unexpected upgrades. Justice isn't blind, it's distracted, overworked, and occasionally too polite to say no. We always reach for the impossible, but sometimes it's because no one stopped to ask if we should. That's how good intentions morph into legal curiosities, how procedural fairness becomes a loophole, and how compassion, without boundaries, turns into a tool for those willing to stretch it past recognition. The real tragedy isn't that these laws exist. It's that the system clings to them so tightly, afraid to admit that fairness can sometimes fuel absurdity. This has been the Absurdist Files, where logic takes a vacation and reality writes the jokes.